a decree? So a decree is defined under section 2 subclause 2 of CPC as a formal expression of an adjudication by the civil court which conclusively determines the rights of the parties in relation to all or any of the matter of controversy in a suit. Simply to put, a decree is an official declaration of court's decision regarding the rights and obligations of the parties who are involved in the lawsuit. Okay, and it always is a final decision, okay, not as order that is passed interlocutory or that is also temporary. A decree is issued after the judgment has been delivered and it can be either preliminary or final. We see in case of partition suit, first a preliminary decree is drawn and then a final decree is drawn. So a decree must be formally drawn up and must align with the judgment passed by the court. Now what are the essentials of a decree? So there will be adjudication. So there must be judicial determination of matter in dispute. So there must be a suit. So the decree must arise from a civil suit. It cannot be issued in non-contentious proceedings. It must determine the rights of the parties. So it must determine the substantive rights of the parties, not merely procedural right. Conclusive determination means it must be final and not subject to further adjudication between the parties. Then formal expression. So the court's decision must be expressed formally in writing and it must be signed by the judges. Now types of decree. Preliminary decree, I have already told you in partition suits, first preliminary decree is drawn and then the final decree is drawn. So preliminary decree means this is issued when the court decides the rights of the parties but require further proceeding to fully resolve the matter. So for example, in partition suit, a preliminary decree may be passed to define the shares of the parties, and in final decree they will publish the shares. So final decree, so this decree is fully and finally dispose of the matter in controversy between the parties. So once a final decree is passed, there is nothing left to be decided in the suit. Okay, it is considered as final. Now there are some decrees that are partly preliminary and partly final. So in some cases a decree may be both preliminary and final. For example, in a suit for possession of the property and men's profit, the decree may be final regarding the possession, but the preliminary decree regarding the determination of men's profit will be pending. Now deemed decree. So certain orders that resemble decree but are not formally classified as decree, they are considered as deemed decree. For example, the rejection of plaint under order 7 rule 11 of CPC is treated as a deemed decree. Now what happens? What is the legal significance of a decree? So a decree has a legal binding force and can be executed through enforcement mechanism if the party against whom it is passed fails to comply. A decree may be appealed and the appellate court may confirm, modify or overturn the decree. The execution of a decree involves taking steps to enforce the rights that are already determined by the parties, or already determined by the court. So whatever has been already held by the court, they have to now enforce that.